the International Covenant on Civil and Political Rights, the preamble. It states the following: recognizing that in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only, only be achieved if conditions are created. Conditions are created whereby everyone may pursue his civil and whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights. You see, the person, the legal person, the Canadian citizen, has to pursue after his civil and political rights, as well as his economic, social, and cultural rights. However, the human being has the right to enjoy these rights and freedoms. And these rights and freedoms can never, never be limited or abridged. And the domestic state party here in Canada is very well aware of that fact.
The Immigration and Refugee Protection Act. Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. Objectives and application. Article 3. The objectives of this Act with respect to immigration are A. To permit Canada to pursue the maximum social, cultural, and economic benefits of immigration. Article 3. This Act is to be construed and applied in a manner that F. Complies with international human rights instruments to which Canada is a signatory. When we look into the Immigration Act, its federal enactment, we find out in Article 3, subsection 3, subsection F. This sentence, this operation of law, this expression clearly brought forth. Canada is a signatory to international human rights instruments. Now we know that these international human rights instruments that Canada is a signatory to are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. So here you can go in to the Immigration Act, go to Article 3, subsection F, and you can pull out this sentence from this enactment to bring forth to the de facto governments, to bring forth to those who are sitting in de facto power, the fact that they are indeed under obligation and they are in fact a signatory to these international human rights instruments. And therefore, the operations of law, our fundamental rights and freedoms, our natural freedoms, our foundational law, ground law, natural law that is being expressed in the Constitution Act of Canada because of the obligation of these international instruments are what we are seeking to evoke and stand upon. The Emergencies Act. This is a federal enactment. And whereas the Governor in Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged even in a national emergency. Canada is a signatory to the international human rights instruments. Now, as being a signatory, they have an obligation to respect the rights and freedoms, even more so those fundamental rights and freedoms that are found in these international instruments. When we look into the federal enactment, the Emergencies Act, it states that the Governor and Council basically the Parliament of Canada, must have respect to the International Covenant on Civil and Political Rights. So they name for us, they bring forth for us one of the international instruments there that Canada is obligated to follow, the rights and freedoms thereof. Now it states this, it says that with respect to those fundamental rights and freedoms that are not to be limited or abridged. Now notice that sentence. It says that there are a set of fundamental rights, okay, that cannot or are not to be limited. So that would mean when we go into International Covenant on Civil and Political Rights or into the International Covenant on Economic, Social and Cultural Rights, we are going to find fundamental rights and freedoms that cannot or should not be, or there is no operation of law to limit or abridge these rights. And we can go to this Emergency Act here in Canada to show that Canada does indeed understand that operation of law, that point of law, that within these covenants there are fundamental rights and freedoms that nobody has. Nobody has the power to limit or abridge, including the Governor and Council, including Canada. And it's in their own law. In the International Covenant on Civil and Political Rights, according to the Emergencies Act, we are seeing that there are fundamental rights and freedoms within that enactment that can never be limited and they can never be abridged, never taken away from you. No prescription of law can be applied upon these rights to remove them. However, we also know that in the International Covenant on Civil and Political Rights, there is a measure, there is ways to prescribe these rights and freedoms. Not these same rights and freedoms, but there is a measure. They can limit and they can prescribe by law some of these rights and freedoms. They call it a fundamental principle of justice. Now, the rights and freedoms that they prescribe, they're doing it to the legal person, the Canadian citizen. The rights and freedoms that cannot be limited or abridged, they belong to us, the human beings, the men and women on this land, our natural rights. You see, those rights, such as Article 11, where everyone has the right to enter into recognition as a person before the law, but no obligation, that's an expression, that's, if you will say, operation of law that secures our common law right. We don't have to take recognition as that legal person. And that right can never be limited or abridged. Nobody can force us to take recognition to play a role of a person, of a legal person. No one has that right. No one has the power to do that. So that right that we have as human beings not to enter into recognition as that legal person is protected by the International Covenant on Civil and Political Rights. And that one article law is a common law expression of a man's right to decide how he will be designated. And that right and freedom, that fundamental right and freedom that we have, that is expressed in the International Covenant and recognized by the state party and places an obligation upon that state party, can never be limited and never be abridged. No prescription of law can be placed upon it. And Canada knows. They're very much aware of this. As you see, we're looking into the Emergencies Act and it states it very clearly. We look into the Immigration Act and it states it very clearly that Canada is a signatory. All these operations of law are here and they are finding their expression, they're finding their measure of being within Canada, but there's only seems to be the higher-ups, the individuals who sit in the, if you will say, the ruling capacity of this country that know all about this. The ones that going down the ladder are unaware of all this. As I always say, otherwise they'd be operating under their human rights and fundamental freedoms. They wouldn't be sitting there in a position where they're pursuing a living and being taxed and being controlled by the government in that way. So it's completely clear that the International Covenant on Civil and Political Rights, when they're talking about our natural rights, when they're talking about our common law rights, when they're talking about our human rights, our fundamental freedoms, as a human being, they can never be limited or abridged. And you see that expression of law directly in the international covenants within the articles, where it states that these rights and freedoms for men and women, they can never be removed. They can never be abridged. Well, it comes out again in Canada's own domestic law. Our fundamental rights and freedoms can never be limited. Never be limited. And Canada, as a state party to these international human rights instruments, have an obligation to allow their expression, the articles of law, the operations of law, to allow their expression within this state territory. They must allow it. However, through fundamental principle of justice, through words, through operations of law, they change our designation in law. They change our designation from being that human being, man and the woman, to being that legal person. And then, on that legal person, they apply prescription law. And they limit the rights and freedoms that that legal person has. However, when you realize what's transpired, and you see that you have fundamental human rights and freedoms that can never be taken away from you, then your next step is to deal with this change in designation that they've applied against you. You want, through a claim of recognition, through a communication with the government, let them know that you are aware now that you have fundamental human rights and freedoms, you have common law rights that are expressed in the international covenants and in the domestic articles and domestic enactments on laws, and that these produce an obligation upon Canada, and they must allow you to operate your fundamental rights and freedoms. And up till now, they have not only not allowed you to operate those fundamental rights and freedoms, they never even taught you or exposed you or gave you the information that they were there for you to use. So this produces a great claim, if you will, a big claim against the state party, if they refuse, at the point where you begin to contact them, to continue to play games and to try and deny your fundamental rights and freedoms. There's no operation of law that allows them to limit, to prescribe your fundamental rights and freedoms as a human being. The minute they say, yeah, but, or if, or I don't agree, they are in default. They are breaking their obligation, they are breaking operations of law, and they can be held accountable. This depends how much you understand about your rights and freedoms and their function here in Canada.